Supplement. On supplementary list, item number 1.
Any mention? First you do it, otherwise in course of hearing and you mention, I'll not allow.
May please, Your Lordship. Lordship, I beg to make a mention of item number 12, Your Lordship.
Number?
Item number 12, Your Lordship. On behalf of Mr. P. Nongbu, Your Lordship, he's indisposed, Your Lordship.
Who's for the here for?
Respondent number 4, Your Lordship.
Who's for the petitioner?
Sir Asu, Your Lordship.
He's not here. Have you sought his consent?
No, Your Lordship. I have not found in the premises, Your Lordship. I'll inform him, Your Lordship.
He may object. This is a matter which is connected with the DB matter.
Yes, Your Lordship.
Are you sure?
Yes, Your Lordship.
On pre-made by the respondent number
4, Your Lordship.
This is matter after 2 weeks.
Much obliged, Lordship.
Supplementary list, item number 1.
So I have considered all the submission made by some of the council on either side, and I've also taken the help, or rather relied on some of the orders passed by different high courts. It is also this court's view that the procedure, as far as procedural law is concerned, the BNSS would prevail. If it, proceedings may be, if it is before the trial court, proceeding may continue under the CRPC, but where bail is concerned, we are talking only about the procedural aspect.
My lord.
Procedural aspect.
My lord.
Though, you see, it would not matter much.
My lord.
Because they are all paramateria.
My lord.
Procedure would be the same, principle would be the same.
Same.
Yes. So since this court is dealing, and this matters specifically only with regard to bail,
My
I will
lord.
not touch other
My lord.
aspects.
My lord.
Since this court is dealing with the issue of bail and anticipatory bail, the authorities cited herein above at para 24, 25, 26 and 27 are found to be acceptable and in line with what this court would understand as far as the subject matter and issue is concerned. Accordingly, where procedural law is concerned, post 1/7/2024, any application, be it bail or otherwise, would have to be preferred under the related provisions of the BNSS 2023, where no such application are pending as on 1/7/2024.
My lord.
In view of the observation made herein above, this court finds that the contention raised by where's Mr. Sincon? Mr. Sincon, Leonardji, cannot be sustained. However, while allowing the parties to prefer their respective application under the BNSS, this court would allow conversion of any application filed under the provisions of the CRPC into that of the BNSS. Respective parties are, however, directed to make necessary correction in the cause title or the body of the application as the case may be.
Deeply obliged.
Instead of filing a separate application, you are allowed to do that. But you be sure. I think Mr. Suna, you have filed under the old code.
I'm filing under the old code,
So
my
you
lord.
just make the necessary correction.
I'll do that, my lord.
So this is the order.
We'll correct it by hand.
You can correct by hand. Just initial,
Yes, my lord. We'll do it.
Deeply obliged.
as you do in checks.
My lord.
Highly obliged, my lord.
We'll take up the matter now. Order is passed, so we'll take up all the respective application instead of fixing another date for call out. call out with going in. Or call out any item. Yes, item number 1. No, we Mr. Evan, we'll take up this. The orders that have passed us now. These cases will be taken up now.
Oh, my lord.
Instead of fixing another date for the same, that will take some time. Yes, Mr. Suna, what is your case?
Lordship, I pray if the matter may come up after some time at the end of the board, Lordship. Mr. Shulai is on legs before a division bench.
I think we'll go by, because it's item number 1, so all these cases are listed. So we'll go by case number. This is 12 or 13. AB 13.
That is Thota.
Thota,
Yes.
Mangalayam, Mangata Rayu. Who's there?
And this is that anticipatory matter, my lord. We are praying for a transit bail, my lord.
Transit bail?
Yes, my lord.
Is there any specific provision under the BNSS as regard transit bail?
No, my lord, we are only seeking 430. 432 will cover, my lord. Even the aspect of transit bail, even 432 will cover, my lord.
Who? And who are the parties? So, Mr. Segon, you are in this case.
My lord.
As far as 2, 3 and 4 is concerned, you have to take steps then?
Yes, my lord. We may be allowed, notice may be issued to them, my lord. We will take steps.
You file this petition under
482, my lord.
old code,
New act. New act.
My lord, one more aspect, my lord. The petitioner in this case, my lord, she is not the resident of Meghalaya. She is the resident of some other state, Andhra Pradesh. And the FIR has been filed in Mumbai.
She is presently residing in Shillong.
She is not the resident of Meghalaya, my lord. That,
He's saying she's not resident, you're saying she's staying in Shillong?
my lord, her address is
Mentioned in
given.
the cost title, my lord. As of now, she is in Shillong.
What is her occupation here?
My lord, well, she is a housewife.
What is this case about?
This case pertains to child trafficking. She has been alleged something happened somewhere in Andhra Pradesh and also in Mumbai, my lord.
Can she approach this court, my lord? That is the
Where's
question.
the FIR?
FIR lordship will find at
Case number 13, my lord. Type copy.
page 13.
No, if she is not related, why would you file an
My
additional
lord,
application?
she was working in an NGO which NGO appears to have been involved in this particular case. She has no connection whatsoever, but
Her name
just
is
to
not
prove
there
her
even.
bona fide, my lord, she wants to go and appear before the IO concerned or maybe the court concerned.
But if she's not named, then where is the apprehension?
She has not been named, my lord. Here, what has happened, my lord, everybody is brought into the loop. And she is, since, my lord, this particular lady also is concerned with that particular NGO, my lord.
Any notice under the assault? Section
No,
41?
they have not issued, my lord. That is giving us more apprehension, my lord, to
Now, my lord, where is the question of apprehension, my lord? When her name is not there, no notice was also given.
No, my lord, here because she has been repeatedly getting calls from different person who, my lord, alleged to be a person concerned with this particular case.
Where is the call records?
But call records we have not enclosed, my lord. We are not in a position to even, but she has been receiving it. And in fact, she has also been informed by so many sources, my lord, back home, that my lord, people are looking after her. Well, at this stage, I'm only praying for the notice to the other respondent. Well, let them come because it's their FIR.
That part will
The
come.
state here has
that
hardly
part
any
will come
concern.
later. First, you have to prove your bona fide. First, you have to, as Mr. Singh said, you have to convince this court that you have a case of apprehension. If that is
Well,
not
this
case, that
FIR
missing,
is
then-
directly as against the particular NGO.
You said she is working in that MGO.
Particular NGO, yes, ma'am.
Where's the proof to that? Any ID card? Any indication?
As a matter of fact, my lord, her co-worker has been arrested already.
That's a different thing, Mr.
That is there,
That
my
is a
lord.
different thing, Mr. First, you prove your bona fide. And what prevented you from filing an application, at the place where the FIR was filed?
My lord, we are only apprehending, my lord. If we go there, I may be arrested. But your lordship is aware, my lord, a mere apprehension is good enough to approach, my lord, your lordship with.
See, apprehension cannot just be in the air.
But that is why, my lord, we have been repeatedly receiving calls from different sources.
You're not
my lord.
even able to prove that.
Well, I mean, we will produce the records, my lord, if your lordship allow.
We'll take it up on Monday. Oh no, today is 27th. Monday,
My lord.
on prayer made by Mr. Thapa. This is matter on Monday.
All right.
Tiberius AB 15.
I call this anticipatory lordship under new act lordship. New act lordship. If your lordship be kind enough to come to the FIR lordship first.
Who is appearing?
Mr. Sheikh is appearing lordship.
Where's
If your lordship, first of all, if your lordship be kind enough to come to the FIR lordship, that at page, translated copy will be at page 13 lordship.
page?
13, 1-3 lordship.
Yes.
Yes. I will be allowed to read lordship. With reference to the subject cited above, Miss such and such, under 18 years of age, daughter of such and such, and Sri such and such.
POCSO?
Yes, lordship. Was married to Sri Donald Nongset, son of Sri Suman Walang from Dash village. That this man has not raped her, but with love and willingness they have lived together from the time she was pregnant. He did not leave her till this day, even after she delivered the baby. So, sir, on our behalf, we, the mother and father, don't want them to do this. We teach them not to marry at such a young age, but when the children does not follow our teaching, we are helpless. Therefore, on our behalf, as a family, we do not want to force a person to come and stay together if he doesn't want, and we don't want this matter to be enforced as per law or lodge an FIR. With a unified decision taken as a family and with one intention, we have nothing to do, though it might fall under the law or can assist. So, lordship, based on this FIR lordship, the accused person has been arrested, lordship.
Arrested?
Accused person. Now, if lordship, out of the blue, lordship, on 14/6/24, lordship. On 14/6/24, the police, lordship, came to look for the petitioner, lordship. Came looking for the petitioner in-house.
Who is the petitioner?
Petitioner is Tiberius Karmandai. And the accused person who has been arrested and who is the husband of the victim, his name is Donald Longset, lordship. The person who's married to the victim
So
is done alongside.
what connection has the...
That's what, Your Lordship. Out of the blue, Your Lordship, the police came looking for me, Your Lordship. Now, since the police came looking for me, Your Lordship, I have the apprehension of being arrested, Your Lordship. So I move an anticipatory bail, Your Lordship, before the learned trial court, Your Lordship. Now, the learned trial court has rejected my anticipatory bail application, Your Lordship, based on one observation, Your Lordship. If Your Lordship be kind enough to come to page 19. Last paragraph, Your Lordship, second last paragraph. Having heard, this is the anticipatory bail moved by the petitioner, Your Lordship. Having heard the submissions of both the learned counsel and on perusal of the material on record, it is seen from the intimation report dated 13/6/24, submitted by the IG WPSI Len Chidi Sangma, where in her report she has stated that the arrested accused Donald Longsit, in a statement, has stated that the victim has been in a relationship with the petitioner, Your Lordship. And the same has been confirmed from the victim that the petitioner is a father of a daughter. Now, based on this statement given by the accused person who has been arrested, Your Lordship, the police came looking for me, Your Lordship. Whereas in the FIR, it's clearly mentioned that the accused person has been arrested and the victim has been in a relationship, Your Lordship, till she conceived, Your Lordship. Nowhere is my name is mentioned in the FIR, Your Lordship.
Can you take steps?
Yes, Your Lordship.
My lord,
On the next date, you
My lord.
produce the CD on the next date. Heard, Mr. Arvind Jha, learned counsel for the petitioner. This is an application for grant of anticipatory bail under section 482 under bracket 1 of the BNSS 2023. The respondents number 1 and 2 are the state of Meghalaya and the investigation should be investigating officer. The related FIR and the subsequent police station case file registered being, what is the case
Mong
number?
PS case number 22,
Mongap PS case
bracket
number
5, 24, under section 5J,
under bracket J and bracket
Roman 2.
oblique 6
Yes.
2024. Since the survivor has also been impleaded as respondent.
Lordship,
Yes, Mr. Shi.
here the survivor is not added as a party, Lordship.
It's a
Who's-
complainant, Your
Oh,
Lordship.
sorry, complainant.
As per the Supreme Court guideline, Your Lordship.
Complainant.
My lord, in the bail petition, Lordship,
Yes.
my lord, my friend might have corrected the cost title. Is all right, Lordship.
Corrected, Lordship.
I'll take the corrected copy from my friend.
The petitioner is directed to take steps for issue of notice upon this same. Notice returnable within 2 weeks. Take steps.
In the meantime, Lordship, interim protection be given, Lordship.
In the meantime, as prayed for.
My lord, this is a POCSO case, my lord.
Also, but you see, we don't know what is the details are not with this court. Even if had there been the statement of the survivor, perhaps that could have been, material. Anyway, this is a grant of prayer for anticipatory bail. We'll see until the next date. You file the status report. I mean the status report and the CD. The listener is allowed to go on interim bail on condition that he shall appear for the IO as and when required, and that he shall not abscond or tamper with the evidence and witnesses. Mr. S.A. Sheikh, Leonard J. appearing for the respondent number 1 and 2 for which no further notice is required to be issued upon such respondent, is directed to also produce the copy of the CD and the latest status report of the investigation. Interim? Yo. This is matter on 10th September.
AB 16.
Maaf.
Gopal Krishan.
Maaf.
May I please the lordship? My lord, what happens here is, my lord, the affair was lodged by the person who has given me a power of attorney. A general power of attorney was issued to me to run a bonded warehouse, my lord. And then, my lord, that is on page 31, my lord. If my lord, I can take my lord to page 31. This is general power of attorney was executed in favor of me, and it is a registered general power of attorney, my lord, on 29 January 2004, my lord. And I was asked to run the wine shop, my lord, because the owner of the wine shop was busy, my lord, with our household. My lord. Then, my lord, she realized that she is in a financial crunch and all, my lord. She has asked me to be a partner, my lord, to be a partner, and then a deed of agreement was signed, my lord. That is on page 41. And I have invested the money, my lord. Page 41.
Yes.
Page 41, my lord. If my lord may kindly come to page 43, para 2. Para 2, my lord.
Yes.
The first party has already applied for changing the name of the bond from so and so to so and so. The second party has already deposited a sum of rupees 1,20,000 only, being the licensing fees for the year 2003-2004 for this license number, my lord. And then, my lord, para 3, on and from 1 to 2004, the second party will be in complete charge and control of her bonded warehouse and manage the entire business on his own without let or hindrance from the first party by investigating his own money in purchasing and storing the IPFL, by engaging staff for various aspect of the business, by paying their rent, electricity bill, telephone bill as part of the expenses of the business, my lord. Now, my lord, everything was done by me. Now, my lord, when the daughter of the complainant was matured, my lord, they have revoked the power of attorney, and then they have asked me to, my lord, to wind up myself, my lord, and they will run the business, my lord. Now, my lord, if my lord may kindly come to the NOC which has been issued, that is on page 48, Annexure 4, my lord.
Yes.
This is to certify that Gopal Kishan Gaur has no liabilities or due towards the business, that is Mrs. So and so bonded warehouse, and officially released from all his duty. This is on 2002, my lord. Now they have said, my lord, there is no liabilities against of me. Subsequently, my lord, I have also given them an agreement, my lord, that if any liabilities come, if anything cropped up, my lord, I am ready to pay. You please inform us. Now, my lord, she lodged an FIR. That is on page 56, my lord.
Yes.
Now, page 56 is, my lord, I am the license holder of bonded warehouse by the name of so and so warehouse. I had appointed the petitioner, my lord. Petitioner asked my manager to look after the affairs of the warehouse under his full control since February 2004. In the year 2021, September month, he handed over the control of the warehouse to me, stating that all government dues are clear and the remaining stock is in the godown. However, later I learned that the excise duty amounting to crores of rupees is due to the government and the godown was empty. He has misappropriated all the money which was due, and now he has left Meghalaya and his whereabouts are unknown. Further, he has transferred huge amount of money from the bonded amount to his and his own other relatives. I seriously doubt that he has also forged my signature. Now I am not being able to contact him and he has probably changed his mobile number. The above so and so says cheated, misappropriated, fraud and all, my lord. Now, my lord, this is the FIR that I have fraud, whereas she is the one who has given me the NOC that there is no liabilities. Now, my lord, may kindly see the government document that is on page 60, my lord, annexure 12. These are the statement, my lord, that every month we have to submit to the excise department, my lord. Well, she said that the bonded warehouse was empty, my lord. Now, my lord, may kindly see the stock. New register, monthly stock statement of so and so from the month of August 2021. August, I left, my lord. These are the stocks, my lord. Then, my lord, may kindly see the next page also, my lord.
Anyway, see, Mr. D.
My lord.
An FIR has been filed. Now that is subject to investigation.
Yes, yes, my lord.
All these
Yes.
will come under the scrutiny of the IO.
Yes, yes.
So we are not.
Yes, we are not that, my lord. What I want to highlight, only thing what I want to highlight is this, my lord, that the FIR may not be 100% true, my lord. That is why, my lord, I have enclosed this government documents, my lord, which is an admitted position, my lord. So, my lord, let notice be issued at this stage, my lord, and interim protection may be given so that I can appear before the IO, my lord. Because till now, my lord, section 41 notice has also not been issued, my lord. And my lord, may kindly see, my lord, I have been discharged on 2000. And now, my lord, in 2024, my lord, they have lost FIR.
See, but Mr. Day, you are not a resident of Meghalaya.
Yes, my lord. I'm not a resident. Yes, my lord.
So where is the guarantee that if you are allowed to go on bail, you'll appear?
No, I will stay back, my lord, in Shillong. I can undertake, my lord. If I have to leave, my lord, for some other purpose, I will assure this honorable court, or I will undertake, my lord, that I will be present before the IO. There is no hurdle, my lord. And if my lord may kindly come to page 55 also, my lord, that will clear more, my lord.
Anyway, this court will not go into the.
My lord. Please let notice be issued, my lord. Let them produce the
allegation will not be
my lord.
looked into at this point of time.
Let notice be issued, my lord. In the meantime, some protection may be given to my lord.
I heard Mr. SD was submitted that this is an application for grant of anticipatory bail referred by the petitioner herein, who apprehends arrests in connection with an FIR dated 7/3/2024 filed by the complainant therein. 1/3. What's the name?
GLORIN.
Gloria K. Sama.
Sama.
Where is the registration?
FIR, my lord.
Police case registration?
Police case registration is, my lord.
Tura PS case? Where is it?
GR case number 147 of 2024, my lord. Page 59, my lord.
GR case?
Yes, my lord. And police case is also there, my lord.
Police case?
Aramal PS case number. Aramal police case number 25, page 58, my lord. Aramal PS case number 25.
On receipt of the said FIR, the police had accordingly registered case being Aramal PS case number
25
under bracket 5 of 2024 under section 406/417/420/465 IPC. It is the submission of Mr. D that the petitioner is innocent of all these charges alleged in the FIR. However, since he is apprehending arrest at this point of time, this court is accordingly approached with prayer for grant of anticipatory bail. However, at this point of time, Mr. Day would further submit that notice may be allowed to be issued upon the respondent.
The state is the only respondent.
Who is appearing?
Miss, actually, the conducting counsel, she's on legs before another High
Doesn't
Court.
matter. You are there. You are a GA.
Yes.
Then I ask you notice more. Since the respondent state of Meghalaya is represented by Mr. Leonard G, who has accepted notice. Therefore, at this point of time, the direction of this court would be for the state to produce the copy of the case diary and the latest status report of the investigation on the next date fix. As prayed for, the petitioner is allowed to go on interim bail on condition that he shall appear before the IO as and when required, and that he shall not tamper with the witnesses and evidence. On prayer made, this is matter on 11th September.
Hello.
Appeal number 30.
Yes.
One of the petitioner is the wife of the accused person, Shri Thostaning Lingdok Nonglai, who is in custody in the present case for a period of 465 days, my lord. My lord, may I take your lordships to page number 148, my lord, 148 of the order dated 12/06/2024, my lord. Wherein, my lord, considering the delay in the trial occurred, this honorable court has directed the trial court to frame charge and to record the statement of the survivor, my lord.
106.
Accordingly, my lord.
You're referring to page?
Page 148, my lord, 148.
Yes.
Yes, my lord. Kindly come to the last line, my lord.
Yes.
However, while rejecting this application, this court would direct the trial court to immediately frame the charges and to examine the survivor at the earliest, within a period of 3 weeks from today. After the deposition of the survivor is recorded, the petitioner is at liberty to approach a trial court or this court for the fresh consideration of the prayer of bail. So, my lord, I'm here before your lordships, my lord, for the bail, my lord. And after the liberty granted by the court, my lord,
charges have been framed? Yes, miss. Charges have been framed?
Yes, my lord. Yes, my lord. Charges have been framed.
Any witnesses? Any witnesses? Statement of any witnesses recorded?
No, my lord. No, my lord. No. My lord, my only prayer is here is that, my lord, to kindly issue notice to respondent number 3, my lord, who is the complainant in this case, my lord.
You are appealing for?
Straight.
Heard Mr. S. Said counsel for the petitioner, who at this juncture had submitted that the respondent number 1 and 2 being duly represented by Mr. Argung Leonard J, notice may not be required to be issued upon the said. A fresh notice may not be required to be issued upon the said state respondent. However, it is prayed that notice may be allowed to be issued upon the respondent number 3, who is the complainant. On prayer made, the same is allowed. Let notice be issued upon respondent 3, the same returnable within 2 weeks. List this matter thereafter.
Declare.
My lord, my humble submission, my lord, let the notice be issued through dusty service, my lord, dusty service.
Why?
My lord, on the last occasion, my lord, whenever we
what is the difficulty? What is the difficulty?
My lord, sometimes, my lord, the speed post which is done by the regular speed post, my lord, sometimes it does not even reach the survivor, my lord. It does not reach the complainant, I'm sorry, my lord. So through dusty service, it will be appropriate, my lord, it will reach directly to them.
Notice be issued, nahi? As notice may be also issued by dusty, if so, as prayed for. Fine.
Highly obliged, my lord.
PL number 31.
Who's appearing? What is this matter about?
Also, this is an NDPS matter. So there was a tip-off received by the Deputy SP, Claret, and on the basis of the tip-off, a bolero was chased and 3 people were, 3 accused were taken into custody, and intermediate quantity of heroin was...
Intermediate?
Yes, my lords. That's extremely premature. They are coming here on the grounds of that, of prolonged incarceration. The last witness was examined in the month of April, and the other 2 witnesses, the PWs, they are casual laborers, my lord, from a different state. So this is why it's taking time.
How long were they in custody?
Lordship, since last year. It's been a year.
So you say that the 1 year being in custody means
Lordship,
nothing.
Lordship.
See, what is the yardstick that is,
Lordship, there are judgments to that effect. I'll place it before my lords.
The Supreme Court has time and again
My lords.
impressed upon
That's
the
them, my
courts that prolonged custody is not always beneficial.
But the gravity of the crime also, my
That,
lords.
of course, that will be taken into account,
Lordship.
Who is appearing for the petitioner?
They generally appeared via VC, my lords. They're not here today.
None appeared for the petitioner. However, Ms. Leonard G has accepted notice on behalf of the state respondent. D. Leonard G has submitted that the matter has since been, that the case has since been charge sheeted, and this trial is at the stage of recording of evidence of the prosecution witnesses. So far, 2 witnesses.
2 witnesses.
So far, 2 witnesses have been examined. However, for clarification of this court, the state respondent is directed to produce copy of the CD, including the charge sheet, on the next date fix. Copy of the, and also copies of the deposition of the witnesses whose statement have been recorded before the trial court. This is matter up to 2 weeks.
Nice.
PL number 32.
My Lord, I am appearing on behalf of my colleague S.S. Yadav. My Lord, due to some unavoidable...
Please tell me, what is the case about?
The case number... NDPS matter, my Lord.
Is this a bail application?
Yes,
Or-
my Lord.
What is the stage of the case?
The CC, my Lord.
CC. Yes, Mr. Khan. Produce the CD.
Lordship, yes.
Heard, Mr. Counsel for the petitioner, who has submitted that this is an application for grant of bail of the petitioner is the accused.
Mother.
Mother. Come to go. On grant of bail in respect of, what's the name of the accused?
Daniel CM.
Shri Daniel CM, who was arrested in connection with, what is the case number?
Case number is...
NDPS case number 21-7-2023 under section 21 under bracket C and 29 of the NDPS Act. It is also submitted that the stage of the case is for consideration of charges. However, the petitioner had now approached this court for grant of bail on behalf of the said accused in question. Mr. K. Khan, LLPP, has accepted notice on behalf of the respondent, and as such, no formal notice is required to be issued. The prosecution is directed to produce copy of the CD, including the charge sheet, on the next date fix. This is matter of the... When, Mr. Khan, can you do it?
Within 2 weeks.
2 weeks, maybe 2. Now we are on...
Now we are on 27th. Any day before 10th, Lordship.
9th, eh?
Okay.
This is matter on 9th.
BL number 33.
May please, Your Lordship. Lordship, this is a bail application filed by the mother of the accused person.
POCSO.
It's POCSO case, Your Lordship. And this is a love relationship.
So you take steps for issue of notice. What is the stage of the case?
Now it's a evidence stage.
Evidence. How many witnesses are being examined?
Complainant and survivor.
How many witnesses are there altogether?
I think left four witnesses.
Oh, so 2 have been examined. 2 left. Then what is there?
No, but survival also now it's a part. It's not yet completed. It's not yet completed for survival.
Yes. So survivor have been examined.
Yes.
And the complainant most probably.
Complainant was examined.
2 more left. Maybe the official witnesses would be.
4 more.
4 more.
4 more.
How long he's been in custody?
He's 6 months now.
6 months.
6 months.
Same, Mr.
Lordship, notice may be issued to the complainant and
Yes.
the survivor. 2 and 3.
In the meantime, you try to
Lordship, yes. Absolutely.
copy of the CD and the
Lordship.
this court would like to go through the deposition of the witnesses who have been examined. Get a copy of that also. Mr. Learned Counsel for the petitioner has submitted that, for the applicant, has submitted that this application is a grant of bail Who is the applicant here?
Yeah, mother of the accused.
On behalf of the accused, what's the name of the accused?
Penchemlat Sten.
Penchemlat
Sten.
Penchemlang Sten, who has been arrested in connection with BMPS case number 2 and bracket 2 of 2024 under section page 4 only. However, the case is now before the trial court, registered as now registration of the case now. NDPS
POCSO case number.
What is it?
Riboy district. Riboy women's PS case number.
No, that is separate. Now once
Yes,
it has been registered, the name has
special POCSO case number 11 of 2024.
As special POCSO case number 11. The Learned Council for Petitioner has also submitted that till date, 2 of the 6 witnesses. 2 of the 6 witnesses have been examined. That is the complainant and the survivor. Stop. Mr. Khan Leonard, PP, has entered appearance on behalf of the state respondent 1 and 2. State respondent 1 and 2. At this point of time, the court would direct the state respondent to produce copy of the case diary, including the charge sheet, and also copies of the deposition of the witnesses who have been examined in the case before the trial court. Straightforward, this is matter.
Lordship, a small suggestion. The last part also the deposition, because it's a non-po PS case matter. Lordship, we don't know what is the stage of the case. So to get the extract would be slightly difficult and time consuming. If the case requires a call for maybe for a day.
I'm not calling for a case report. Why would you call for a case report?
And then
you see what you do is you just give the extract or the case diary, of course, would be there with the
case diary, yes.
Charge sheet would be there.
But Lordship is asking for the deposition done in the court.
It is incumbent upon you are the officer of the court.
Absolutely not. The only thing time consuming, had it been Shillong, Lordship, Nongpo sometime.
It's just a copy that's required. I don't require certified copy.
Okay, then it's okay.
Just a copy.
We'll communicate.
Which would be certified by you personally that is authentic, that's all.
Absolutely, Lordship. Okay. If the certified copy is not required, then
if it's not, then you will be in a dock. So do that. I think those are formalities which can be done by you.
Absolutely.
I don't think it has to be spelled out.
Me, absolutely.
This is matter of 2 weeks.
Lordship, I'm appearing for only respondent number 1, 2 and 3.
Who's 2 and 3?
Complainant and the survivor.
Oh, sorry.
So notice
only for one more.
Only for one.
I will notice upon respondent number 2 and 3.
So do we need to take steps?
I think you have been directed to take steps, so take steps.
Bill number 34.
Okay.
What is the fact?
Okay. Give me a tab now. Okay, only. Yes.
May please be your Lordship. Lordship, I have preferred this bail application. I preferred this bail application before the CGM court Nangpo. The case has been charge sheeted recently, and then the stage of case is not yet trial started. Right? And Your Honor, what happens here? The presiding officer of CGM Lounge Court is on sanction leave, so I could not prefer that. So I have approached the Honorable Court to grant him. So Your Honor, here what happens? The charge sheet has been already done. And then the co-accused has been already released on parity. On the ground of parity, I am void. So, Your Honor, what happens here? I am languishing here in the jail for more than 101 days. So I just pray to before this honorable court to grant this bill, and the direction we were given to the lower court below to accept.
What is the stage of the case, you say?
Case is not yet started,
Oh,
trial.
so-
not
so
yet. Just recently charge sheeted has been submitted, and the GR case numbered as 28 2020.
Charges have not been framed.
Yes, charge sheet has been. Charges has been submitted.
Produce the CD.
The case is yet to be charge sheeted.
No, it's charge sheet. Yet to be charge sheet. That's
It's
what he
already
said.
charge sheeted here.
But a copy of the charge sheet has not been served to us. So that has to be.
Whether you have got a copy of charge sheet. It's in command. You are the prosecution. It should be with you.
Well, it will produce.
We'll produce it.
But Mr. Counsel for the petitioner was submitted that this application is made for grant of bail on behalf of the petitioner is the father.
Yes, Your Honor.
On behalf of the accused person in Umyam PS case number 35 of 2024. It is also the submission of the Internal Council that the charge sheet has already been filed by the IO, and the court is yet to frame the charges. It's yet to consider the charges and to frame charges if so required. However, the prayer of the petitioner at this point in time is for grant of bail on behalf of his said accused person in question. Mr. Argurung Leonard GA has entered appearance on behalf of the respondents, and as such no formal notice is required to be issued upon such respondents. The court, in order to ascertain the facts and circumstances of the case, would direct the prosecution to file a copy of the charge sheet, file a copy of the CD including the charge sheet on the next date fixed.
Yes, sir.
This is matter on 12 September.
Yes. Oblige, Your Honor.
So I'll come back after a while.
Daily list, item number 1.
Lordship, I have filed my
Yes, Your
objection, Lordship.
Lordship, we have received the objection filed by the respondent. Lordship, may kindly post this matter for hearing.
You can hear it now. What is there?
Lordship, after a week, Lordship.
Why?
Some more time to prepare.
Yes, there's no complicated issue of law to be decided here. It's already there in black and white. So you tell me. You are the petition appellant.
Yes, Lordship.
Please start.
Lordship, Learned TSGI will argue this matter.
The counsel appearing on behalf of the DSGI has submitted that the objection to this appeal filed by the Appellant Union of India has been received. It's prayed that this matter may be posted for hearing. Accordingly, this is matter for hearing on 2nd. All right.
Highly obliged, Lordship.
Item number 2.
May it pleases your lordship.
Difficulty may be there with this because
before this bench, your lordship, this matter.
Judgment was passed by Honorable Justice Thank You, and the Lordship Bhattacharjee was the AAG at that point of time, Lordship.
He might change his mind, so what?
Lordship.
I have no issue, your lordship.
This is matter before any bench without Honorable Mr. Justice Bhattacharjee.
We have to wait.
Obliged.
So we have to wait.
Obliged.
Item number 4.
Similar matter, my lord. From the state was being
In view of
represented.
the previous order, wherein it is indicated that Justice B.
That is not a disposal.
Bhattacharjee
No, no.
will not be able to take up this matter.
Suffering from some.
Accordingly, this matter before any other bench without Justice B. Bhattacharjee.
Item number 5.
This is a contempt matter, madam.
Yes, Mr.
May it please your Lordship. Your Lordship, I'm praying for some accommodation for the day, Lordship.
What's the matter with you?
Your Lordship,
Lordship,
Mr.
on the-
Paul is actually, he was on his way. However, there was Mr. Paul. However, there was medical emergency at home. His mom suddenly, she's not well, so he had to return back.
This is the only
That is not well.
this is the only plausible excuse that you can get away with. No, I'm not demeaning
Your Lordship,
the
he has
issue.
not been well for quite a long
On a health issue, we will not join issue, but Lordship, on the last occasion in the order has recorded that the matter is being adjourned regularly.
Yes, that is true, Mrs. Hari, but then what can we do?
Yes, yes.
They are more confident with the senior appearing with a formidable opponent like you. Who would take the risk?
Lordship is too kind.
So, when do we take it up?
Your Lordship, tomorrow,
Tomorrow?
or as per your Lordship's convenience.
Take it out Monday. Mr. Learned Counsel has submitted that has prayed for accommodation, appearing for the respondent, has prayed for accommodation on the ground that the learned senior counsel who is conducting the matter is indisposed on ground of personal difficulty. The prayer not being objected to by the learned GA appearing for the state petitioner, that is adjourned. List this matter on 3rd. Take it on 3rd September.
Item number 6.
May I please, Lordship?
Supplementary first list, item number 1.
Is POCSO?
No, my lord, 307.
307. Extent of injuries?
External.
Extent of injuries.
Serious injury occurring in background. Now, my lord, by this application, the accuser's petitioner is second time before this honorable court. FIR, my lord, will take page 12. Page 12 of my petition.
What is the stage of the case?
Under investigation.
Charge sheet have not been filed.
Not yet. Anticipatory, my lord.
Where is the FIR?
Page 12.
Yes.
If I may read, my lord, with reference to the subject cited above, I, the undersigned, beg to lodge this FIR pertaining to the assault of my brother in an incident at the court on 27/4
I remember this case.
2024 at about 3 a.m. to 4 a.m. at Rajasthan Daba, located at the Chivide Juwai bypass. On the said date, my brother's name, Mr. So-and-so, was roaming with his friend, whose name is Mr. So-and-so, son of Mr. So-and-so, resident of Lamkla village. Information was intimated to me and my family.
Yes, I think Mr. Suna, there are some eyewitnesses who have seen you.
Yes, my lord.
So what is the...
My lord, if I take my lord to the first rejection order by the trial court, the observation made by the trial court.
Page?
Page 20. Para 11, my lord.
Yes.
This court find that there are prima facie evidence to show that involvement of the petitioner accused and the CCTV footage clearly show the participation of the petitioner, which is highly disturbing when such evidence are there on record. The benefit of pre-arrest bail cannot be extended to the petitioners. Against this order, my lord, I have approached the petitioner approached this honorable court for the first times, and this honorable court by orders 11/6/2021 dismissed the application of the petitioner on being withdrawn. If I may take, my lord, the order of this honorable court, page 25.
Yes.
It's a two paragraph. If I may read both the two paragraphs, my lord.
Yes.
In course of hearing, Mr. Andy Shulai Leonard AEG has produced copy of the case diary and also the status report dated 10/6/2024 filed by the IO. However, the party would impress upon this court that merit of the case may not be looked into and that the petitioner may be allowed to withdraw this instant application with the liberty to file afresh before the court of the Leonard Session Judge, West India Health District, Juwai. SM Suna Leonard Counsel for the petitioner submit that while considering the said application, the Leonard Session Court may call personal appearance of the IO for clarification on certain aspect of the investigation. This submission was not objected by the Leonard. On the submission, same is allowed this application accordingly dismissed on withdrawn. Now, my lord, pursuant to this order of this honorable court, I again approach the Session Court. And before the Session Court, appearance of the IO has been called. The IO has raised an objection to my bail only on one aspect, that is the stone has been used and other people were involved, vehicle also involved, which is exactly as per the FIR. FIR, there is two versions of error. On the first part, a complainant alleged that her brother was hit by a vehicle. Secondly, complainant says my brother, on the basis of the CCTV footage, he was assaulted by the accused. So before the Leonard Session Court in the second appeal application, the IO has raised an objection to the fact that the involvement of the accused is very much, involvement of the vehicles, and the stone also is being used, which is categorically mentioned in the status report before this honorable court also in the earlier question, that stone has been used. The only point, the only requirement of the IO to arrest the petitioner to retrieve back the stone. So in my humble and respectful submission, my lord, even if the accused taken into custody, it would be impossible for the IO to retrieve that stone because the stone was used, according to them, inside the dhaba, that restaurant. Now, secondly, my lord, if you if my lord takes the, if I may take my lord to the second order passed by the Session Court rejecting my bail application. paragraph, relevant paragraph, page 39, my lord.
Yes.
Paragraph 12 in my read, my lord. The IO who is present before this court clarified that earlier he did not insist on custodial interrogation of the petitioner as the statement of the victim was not before the IO. After his statement was recorded, it was found that other people are involved. Vehicles is also involved. Stone was used for commission of the crimes. As such, custodial interrogation of the petitioner has become necessary for the purpose of effective investigations. Now, my lord, it might take my lord to page 41, paragraph 14, finding of the Honorable Court why rejected my application. This Honorable Court reiterate the CCTV footage of the place of occurrence, which was placed before is very disturbing. The footage is fortified by the statement of the victim. No doubt, arrest of the accused bring dispute to and stigma. The power under section so and so has to be exercised in order to protect innocent people from being falsely implicated, and arrest. New evidence has also been collected and fortified by the events. My lord, my humble and respectful submission. My lord will appreciate in both the order of the Learned Trial Court. The Learned Session Court has rejected the application notice on the same ground, that is on the basis of the CCTV. So my lord, if the CD is called for, the video, it can be assessed by my lord before considering my case. And secondly, on the point of cooperation, my lord will appreciate that the accused petitioner, immediately on being given protection by the Session Court as well as by this Honorable Court, he has made an appearance before the IO on 4 occasions, which goes to show that the accused person has all along cooperated with the investigations. His statement has also been recorded.
So your statement under 161 has been recorded?
Yes, already recorded. Other witness who is an eyewitness who present, his name Mr. Toki Wayorangklem, who is all along present the whole night throughout the incident. His statement also has been recorded. So that also I would respectfully...
We'll call for the CD then.
Maybe look into, my lord.
Lordship, if I may, as per the instructions received from the IO, the accused has already absconded. Right from the time when the order by this honorable
He's right
court,
here.
because the IO informed us that he has absconded, Lordship.
Since he's represented, when we say he, means he's representing the accused. If it is a case of him absconding, then he would not have appeared before this court.
I would have not been here before, my lord.
So,
because
anyway, that's beside the point. He would be, the investigation has not been completed. Charge sheet has been filed.
To my knowledge, still yet have not been filed.
Investigation has not been completed. If he is required to be able to appear before the IO, he will do it. So you produce the CD on the next date.
Because even his whereabouts are not known, Lordship, he's evading arrest.
The court will direct that he appears before you. If not, then you have a case.
Yes.
You can file a report on the next date fix, and he failed to appear before you.
Lordship.
Matter will take its own course. Heard Mr. S. M. Suna, Learned Counsel for the petitioner, has submitted that this is an application for grant of anticipatory bail on behalf of the petitioner. The application being the third of its kind before this court. However, the court at this juncture would not go into the facts and circumstances of the case. Suffice it to say that the petitioner, on his prayer, is allowed to suffice it to say that the petitioner has taken steps for issuance of notice upon the state respondent who has entered appearance through Mr. Leonard G. At this stage, on consideration of the submission made by the Learned Counsel for the petitioner as well as by the Learned G, this court is of the opinion that the case diary is required to be produced. Accordingly, the case diary is directed to be produced on the next date fix, including the video evidence
CCTV footage
of the CCTV footage said to have been recorded at the place of occurrence.
Meanwhile, circumstantial may be clear.
In the meantime, the petitioner is allowed to go on interim bail on the ground under condition that he shall appear before the IO as and when required, and that he shall not tamper with the evidence and witnesses. List this matter on 12.
Daily list item number 1.
Video license.
Sarah matter, want to?
Khan, since we are, just to be, to cut the proceeding short, in the meantime, you, through your own source, try to get, some information on this case, particularly the, the
Involvement
of the, and the statement of the survivor, if at all.
Absolutely, absolutely.
So, gets that it will be easier for us. We can, perhaps at the first instance, we can dispose of the matter if it.
Absolutely.
Let me know when you're filing.
We'll file it today itself, my lord. We just get it correct. We just need to get a signature. File it today.
Okay, in the meantime, yes. Once you file it, then
Or most let us by tomorrow, my lord.
Whatever.
Lordship will do it. We'll do it.
All right.
May it please your lordship. Lordship, this is Harijan matter, your lordship. The writ appeal is coming on Friday. So if it comes after that, your lordship.
I think Mr. Koshi or I had asked the parties later, some point of time, what is the the connection of this case with the one before the division bench. I think it was said that there is no connection at all.
No, connection is there.
What is the connection?
Here I am asking the patta to be issued in my name in respect of the same land.
Okay.
Now, if I am given alternative accommodations somewhere, shifted there, the case will become infructuous. Then I will not press for the prayer anymore.
Lordship, that prayer will come at page 24. Page 24, your lordship.
Yes.
What is the main grievance, your lordship, is against that. Lordship, kindly come to page 107. The type copy at page 108.
Yes.
Lordship, this is the main grievance, your lordship, against this committee, your lordship, because from the very cost title, your lordship, lordship, kindly come to page 7 of the writ petition. The grievances against this committee, your lordship.
Yes.
This committee, your lordship. Kindly see the constitution of the committee, your lordship.
Very common.
Lordship.
Reading page 7.
At page 10, lordship, the main respondent is the high-level committee, which is at page 7, your lordship.
Just to justify my submission, just cursor. High-level committee has given the report.
Just a minute. Then that committee, your lordship, constituting the committee notification is at page 108, your lordship. That is the type copy.
You just pointed out just now.
Lordship, yes. So, lordship, I kindly see the name of the people here, your lordship. Some of them have been. See, like James P.K. Sangma, your lordship, he's no more minister. Then Bante Lingdo, he's no more a minister. Hamletson Dingdo also, he's no more.
Anyway, what happened is this: if this case case proceeds on merits, so the writ petitioner will have to come with an application for amendment.
Lordship, yes.
To incorporate
the newly inducted members.
Or the new members of the
Lordship, yes.
Anyway, that's beside the point. We are not on that
In
now.
this case, if I am going to abandon my claim over the plot of land in its entirety, because I am shifted somewhere else, the entire case will become infructuous. For that reason only.
And what is the case before the
similar prayer that I should not be evicted from there? Then the learned single judge pass an order that even if you want to evict, the government has to prove his titles over the land.
When is the case coming up, Mr.
On Friday, your lordship.
So we'll list this on after 2 weeks.
After 2 weeks.
After 2 weeks, your lordship, yes.
Mr. Kurshi, Mr. N.D. Shulai, Learned AG, has submitted that the matter before the division bench of this court relating to the identical issues raised in this petition is under consideration by the said division bench, and accordingly it is prayed that in the meantime this case may be adjourned for the time being till the disposal of the said said matter before the division bench.
Lordship, yes.
As prayed for, this is matter to
After 2 weeks. Apply, Your Lordship.
Item number 10.
Lordship, I pray to take some more time as we have not get instruction from the department yet.
You are appearing for?
Respondent number 234.
For the Provident Fund, my lord.
This matter has been heard.
Well, this matter was heard, but my lord, what, because there is an ongoing process of some settlement. So no, the last 2 occasions the time was sought, right? So that some settlement is arrived at.
I think the petitioner, if I vaguely recall,
My lord.
they say that the corpus is already there.
Yes.
It is to be sort of distributed to the employees, and that those details are with the EPF.
Some process of settlement is going on, my lord.
At this stage,
Because I think the last occasion also that was the submission. So this matter may be listed after 4 weeks otherwise.
I'll give a last chance to the parties to settle the matter if any, or come up with any solution. Otherwise, the issue involved in this petition will be will be decided. Whatever the outcome, later on you might settle, you might not. That's up to you. Otherwise, you cannot just go on like this. And I ask for you, try to find out those details. If not, we'll go by what is there on record.
My lord, item 10 and item 18, both are concerning this one.
Of course, different issues altogether. One is for the notification.
My lord, in fact, these 2 matters are for the notification. My lord.
Ms. General Counsel for the petitioner, as well as Ms. General Counsel appearing for the respondent 224.
My lord is correct.
It is the submission of the General Counsel for the respondent 224 that the details as far as the employee's status are concerned, vis-a-vis the payment of vis-a-vis the entitlement to the provident fund, could not be submitted today, could not be filed today, since specific instructions have not yet been received in this regard. It is prayed that some time may be allowed for the parties to, for the said respondents to file the report. Mr. K.P. Butchaji, GA, on the other hand, appearing for the state respondent, on the other hand, has submitted that there is talk of settlement between the all concerned, and as such, some time may be allowed for such settlement, if any, to fructify. This court would again reiterate that the matter in hand is a long pending one, and by now parties should have made their stand, which should have made their respective stand clear. Be that as it may, for ends of justice, the prayer is allowed. The parties are, however, requested to make an endeavour for the matter to be disposed of expeditiously. As prayed for, this is matter of 4 weeks.
Item number 11.
So this will be in also in item number?
My lord, item 10 and item 18, my lord.
Same. You are also in
Yes.
those?
Yes, my lord.
This is matter of 4 weeks.
Obliged, my lord.
Lordship, I'm praying for some accommodation, Your Lordship.
I think last time I have, should I say I have directed you, or I should requested you, or I have implored upon you? What words to use to make to compel you to come and make a submission? I'm talking about you personally, not about your senior. You should have done it.
Your Lordship, actually, council is already but there's some urgencies, Your Lordship.
Let's not talk about senior counsel or junior counsel here. We're talking about counsel of the appearing before court, who's expected to be equipped. You are handling, you or your chamber is handling the brief. You should be well, versed with the facts and circumstances. So you start. If this is the way we are going, then what do we do? Who's appearing? All the respondents are here. Mr. You are for?
Also for respondents, Lordship.
So 4 and 5. Who's for 4 and 5? You are for 4 and 5. And 6. See, all the respondents are here. We could have finished off the matter. Yet again, accommodation is sought for on behalf of the commissioner on the ground of the indisposition of the learned senior counsel who's conducting the matter. This court, on consideration of personal difficulty of counsel, would more often than not allow such prayer, but considering the fact that this is a long pending matter, the counsels, the parties, rather the counsels of the respective parties are requested to ensure that the matter is disposed of, is being heard expeditiously. As prayed for, this is matter of the 1 week.
Item number 13.
Oh, that is report.
Yes, this is with regards to the
ongoing project, whether it is still there or not.
Yes, this that in the last occasion that your Lordship have directed the state to file a report, status report.
Lordship, there was no directions, but then
no specific
direction. As per our knowledge, that as per instruction.
Lordship, as per my recollection, Lordship, the petitioner wanted to bring on record the status report, Lordship. If that's the case, Lordship, then they can file it and we can
bring on record. As we have said that this route has been abandoned. The project has not been completed.
But how would that affect the merits of this case?
Your Lordship,
what is your prayer here?
Our prayer is page number 11. May I read, Your Lordship?
See, your prayer is basically for quashing the NIT. But in course of these proceedings, it has been submitted that
Lordship, 80%
the
of the works
process-
has already been
process
completed.
is already over.
Lordship.
The tender has already been settled.
Yes.
Lordship.
And somebody has undertaken to carry out the work. So, like if you say now that 80% of the work is done, so what is left? You have no case.
Your Lordship, is that our grievance now is that because the state government, the SPV fund has been diverted to the departmental
Yes,
project.
I understand that.
So,
but is there any specific prayer or averment to that extent?
in prayer number 3, Your Lordship.
You see, if that is the case, excuse me, let's put it this way.
Yes.
Even if the project is carried out, whether it's completed or not completed, that would not affect your case. It may have been completed, it may not have been completed, but the fact remains that at this point, your grievance would be that the amount sanctioned for the cost of the project should not be taken out from the SPV,
Yes, sir.
but it should be from the regular
Regular funds.
fund or whatever. So that would be your case. Now we have to determine that fact. Those are questions. Of course, I know whether the affidavit have been filed.
Lordship, we've already filed an affidavit. Lordship, we've made our submissions with regards to that with the averments, Lordship. I made a reply with regards to the averments.
Whether you would say that the amount that is used, the fund that is being used, is from the SPV or from the general fund or fund meant for it. If that question is answered, then the matter ends there. We have nothing as far as project. I mean, the status report is concerned. I don't think we should go into that. We'll look into the
and this
merits.
matter also is since 2020.
So now see
small issues.
Anyway, if your grievance, if your objection is for the use of the fund, that issue will remain. That issue will remain. Eventually, if it is found out that the fund has been used from the SPV and it has to be refunded, then it will be done so. This court, by its order dated 2/8/2024, has directed the parties to submit a status report as regard the project that has been the focus of the parties, wherein the petitioner has asserted that for such project the funds utilized was from the corpus of the funds meant for the special purpose vehicle SPV, when actually it should have been utilized from the general fund of the government at the disposal of the Public Works Department. However, as submitted by Mr. A.H. Harolang, Additional Senior GA, the issue as to whether the project is completed or not, or the stage of the work as far as the project is concerned, has become academic, in as much as the NIT challenged by the petitioner has since been settled and the work has been allotted, and accordingly the project is underway. However, the learned counsel for the petitioner would submit that the other part of the prayer made in this petition is as regard the utilization of the funds, and has reiterated that the fund used for the project was out of the SPV, which it ought not to have been used. Accordingly, this court is of the view that the main consideration now would be as regard the said utilization of as regard the utilization of the said fund. This petition will now be heard accordingly. Will now be heard on merit on the next date fix. We'll finish it off the next date. How soon?
1 week.
1 week.
Also after 2 weeks.
And one small request, Your Lordship. It is better that the state will file a status report of the project. This project.
Like I said, it has to come.
So then we will have.
Even if, again, we are coming back to the same thing. As I said, even if the project is half done, 3/4 done, or fully done, it makes no difference. What your concern is utilization of the money.
Yes.
If it is done through the fund of the SPV, then it will be returned. Simple as that. This is matter to 2 weeks.
Yes, sure.
Item number 14.
Yes.
Watch the arguing counsels.
Pardon?
Lordship, if the matter can be taken up at your court, Lordship, the arguing counsels, I think so, is in on legs before the other court, Lordship.
End of the board.
Lordship, Lordship, for 2 and 3, Ms. Senior Counsel T.T. Dingdo is representing them.
No.
Seems he's on leave, Lordship. It's but a costless. There was a mention made in the court number 1 as well, Lordship. So far as 2 and 3
nobody is here to represent him or to make a mention.
Lordship, that's what I was trying to search them, but they're not here.
Mention is made by the learned counsel that the learned senior counsel, Mr. T.T. Dengdo, who is representing respondents number
2 and 3, Lordship.
2 and 3, is indisposed on ground of personal difficulty. Accordingly, on preliminary by parties, matters adjourned. Listing after 2 weeks.
Hello,
2 weeks.
Much obliged.
Item number 15.
Please, Your Lordship. Lordship, I'm seeking for accommodation, Your Lordship, in this matter.
See, when the court, the moment the court commences its proceedings today, I had called upon the parties who are, seeking adjournment to make a mention. You have not done it. And I also specifically said that if you don't make your requests, at the outset, no adjournment will be allowed. Now you come in.
My apology, Your Lordship.
On preliminary by the petitioner, this is matter after 3 weeks.
Item number 16.
For